The Commission can be of tremendous assistance to tenderers who are dissatisfied with procurement procedures. But unfortunately, from the point of view of disgruntled tenderers, that assistance is provided on the Commission's own terms. Allow me to explain. The Commission has spots or identifies difficulties with the public procurement directives in the different member states. And there are issues that are perhaps exist in one member state that don't exist in another. As issues arise, the Commission is prepared to take them up. And if a dissatisfied tenderer comes to the Commission with a problem, and the Commission find that problem to be one either of widespread concern or one that they have a particular interest in, they are very keen to run with the ball and take up cudgels on behalf of the tenderer. So in those circumstances, the Commission can be of tremendous help, up to the point of actually taking infringement proceedings against the member state for what might on the face of it look like a technical breach of the rules, but from the Commission's point of view raises an important issue of principle. On the other hand, if someone goes to the Commission and approaches them with a difficulty which the Commission has no particular interest in, the Commission may be of some limited assistance, but ultimately the Commission will not run with the issue themselves. Clearly the Commission has limited resources and can't take up every single set of proceedings. Also, the Commission encourages individual persons who have a difficulty with the rules and their application to take procedures in the national courts. That's the purposes of the Remedies Directive and the purposes of national rules, allowing access to review of procurement decisions. So in those situations, the Commission is likely to tell the dissatisfied tenderer that they'd be better off pursuing litigation in national courts. The reality of things, however, is that because of the restrictive time limits within which one can challenge procurement decisions, tenderers would be well advised to ride both horses. They have nothing to lose by bringing matters to the Commission's attention. If the Commission take up the issue, so much the better. If the Commission fail to take up the issue, they still have the possibility of litigating the issue before the national courts. And the Commission, of course, if the issue goes to the Court of Justice in Luxembourg, will express a view on the question of law raised in the reference or preliminary ruling before the Court of Justice. Transparency means creating a procedure that someone from the outside looking in can see exactly what went on. It means establishing verifiable and clear criteria for judging tenderers and tenders, and keeping a proper record of how those criteria were used, so as to allow someone who's reviewing the decision afterwards, whether reviewing it in the context of a meeting between the contracting authority and the tenderer, or with the public accounts body, or being even reviewed by a court, that the person reviewing it can quickly find out what happened in the circumstances of that case. The most useful tool for SMEs who are unhappy with a contract that's been awarded is the debriefing meeting with the contracting authority. And whenever an SME is dissatisfied with the outcome of a tendering procedure, they should always seek a debriefing meeting at the earliest possible opportunity, so as to find out exactly why the successful tenderer obtained the contract and why they failed to do so. But if one takes it a step further down the line and one has concerns after that meeting, then certainly the Freedom of Information Act can be useful in obtaining further information. But unfortunately, or from the point of view of dissatisfied tenderers, and perhaps fortunately from the point of view, everyone else's point of view, the only information one is going to get relates to the dissatisfied tenderer. It is not a mechanism for obtaining discovery and having sight of the for example, score sheets in relation to everyone else. The only score sheets you're going to see are in relation to yourself. So it is of limited use, and it's certainly something that one shouldn't seek automatically. One should first of all obtain the debriefing, consider the position after that. All this has to take place within a very short time frame, but that can be done. And then perhaps it's worth looking into the freedom of information side, which can be of some use, but it's not a panacea, and it certainly isn't equivalent to the type of documentation one would obtain if one took court proceedings, because what is available in a court proceeding is anything that's relevant to the proceedings has to be disclosed by the public authority, whilst a Freedom of Information Act request only has to give you the information that concerns you, And clearly there could be breaches, for example, of confidentiality if information concerning other tenderers were to be supplied on foot of a Freedom of Information Act request.